let's pretend that it started just now. We are having, as you know, a series of construction law seminars, and this is the first of 7 seminars we will be doing until December 2016. And happily we have here Peter Burns to talk to us about construction claims. Peter is an authority in UK construction law, and we couldn't start in a better way. Thank you very much, Peter, for being here with us tonight.
Thanks very much. Can you hear me on this mic? Yeah, good. Yeah, as Angelica says, I've been dealing with construction law for probably 40 years, but over the last 15, 20 years, I've particularly been dealing with it through the adjudication process, arbitration process, and general claims that we have with contractors, subcontractors, and employers. So Matthew, my colleague, my business partner's here also, so he also is very experienced in the process. Now, I'm a chartered arbitrator, a registered adjudicator, mediator, do all that side, but also act for parties. So I'm pretty understand where the claims are coming from, where they're going to go to, how they're going to be resolved, and the things that you need to look out for and be aware of in this whole process. And in the real life, I'm going to cover some of the big areas of concern that we always have when people present claims or try to defend claims for other people on the basis of what things are you looking out for. And if we start off with most claims, construction claims fall into 2 main categories. One is claims under the common law, and one is claims under contract. I'm going to deal with the common law side of it first. Probably you've dealt quite a bit of this anyway through your course, I would have thought, but even still, I'll go through it because the same principle follows through to when we come to the contract. You need to understand the process of the common law, what we're looking for in the common law, and what we're looking for in the contract. So, under common law, obviously we're looking for common law damages as a means of being paid for something through through an action or some breach of contract by somebody else. Now, the purpose of common law damages is a pretty well-known sort of statement that's been put into many cases. I picked up one from 1868, so I thought I'd have quite a topical case on the basis of exactly the same principles have followed through ever since that mid-1800s, when all these type of cases really came into play. And in that one, the wording was, where there has been a breach contract, common law damages are to put the injured party in the same position financially as you would have been in if the contract had been performed. So the purpose of damages generally, and this repeats itself all the way through the years, is if somebody breaches the contract, you need to recompense them financially as close as you can, as though the contract had been performed. That particular case is a very old case, but you'll still see the same phrase coming up all the way through, right through to the 2000s. But when you're talking about common law damages, there's 3 main elements of common law damages that you need to really take into consideration. And these are the parts that sometimes people fall down on in terms of presenting a claim or defending a claim. And they are causation, remoteness, and the duty to mitigate loss. So again, if we take a bit more recent case, 1949, Monarch Steamship case, that established the point, again repeating from earlier cases, that there must be a direct link between the breach of contract and the damages suffered. Now in that particular case, it was quite an interesting case that a ship, the Monarch Steamship, was to transport soya beans to Sweden in 1939. It actually happened. It wasn't until 1949 when the case actually comes around. In 1939, they would take the soya beans to Sweden, but the problem was the engines on the ship were defective, etc., and it was taking a very, very long time to get to where they was going to go. Added to that, before they got to where they was going to go, war was declared in 1939, and because it was a British ship, they were told to divert to Glasgow. And when they eventually got to Glasgow, no problem at all. But from Glasgow, the person who wanted the soya beans in Sweden had to charter 3 ships to take the soya beans into Sweden. Now, the company, Karl actually said, well, we now want to recover from you the cost of those 3 ships because there's a breach contract. As a direct result of that breach contract, we've obviously suffered damage and we want to recover that cost from you. Now, obviously, the Monarch steamship said, yeah, but hang on a minute, there was a war declared. How on earth could we know that there was going to be a war declared at that particular time? That meant we had to be diverted to Glasgow. So really the loss relates more to the fact there was a war declared rather than to the fact that our ship was breaking down effectively. And when it went to court on that one, it was found that actually the war being declared wasn't the main cause. The main cause was the ship breaking down. Because if the ship hadn't have been breaking down, it would have got to its destination before the war was declared, in which case that wouldn't have been a cause. And this sort of principle of what is the main cause of an issue, we'll see repeated again when we come to things like extensions of time under contract, things of that nature. What is the main cause? You've got to understand what the main cause is. And it's not always easy, because in a case like that, you would think, well, neither party could have known that a war was going to be declared. But the court actually decided, strangely enough, that it should have been their contemplation, because there had been a lot of press and there had been a lot of news about this war that might suddenly come up, and it should have been their contemplation to allow for that in the contract. And it links in with this issue of remoteness of damage. How remote is the damage? So under the, again, our really famous case of Hadley versus Baxendale, 1854, which talked about the remoteness of damage. So in this particular case, somebody was employed to transport a crankshaft to be repaired, and it had to go on a particular day. It didn't go on that particular day. It was late, and so this was when it eventually got to the place where it was going to be repaired. Turned up late. That meant they it didn't get repaired and sent back in time. And in this meantime, the factory, the mill, it was a mill, stopped production. So the mill then was claiming obviously damages to say, well, not only have we perhaps had extra transport costs or something like that, which is the direct part, but the indirect part is we've suffered loss as a result of our loss of productivity for that period of time. And the court in that case found this issue about remoteness, and they said, how remote is this damage from the fact that the crankshaft turned up late? And in this case, it was decided that actually it was too remote, because it wasn't in the contemplation of the parties that the damage would mean there'd be lost profit, because it could be the mill owner actually had another crankshaft. How do we know he didn't have another crankshaft? How would anyone know? And so from that, we get this, what's called 2 limbs of the Hadley versus Baxendale case. And the first limb is the one that is a loss that arises naturally as a result of this particular breach. So something that happens that naturally arises from it. The second one is losses that are reasonably in the contemplation of the parties at the time the contract was formed. So for example, if in that case the mill owner had said, oh, if you don't get that crankshaft there on time and it doesn't come back to me on the following day, then obviously I will be losing production. So I'm telling you now that that will be a consequence of you turning up late. So it would have been the contemplation of the parties that the actual cost and the damages would have related to something that was in the contemplation of the parties. So again, now if you transfer it to our normal everyday life, when you're putting a contract together and you're thinking ahead either to damages or you're thinking ahead to possible loss and expense, then you need to put into the contract something that you think should be in the contemplation of the parties at that time. You need to get it agreed at that time. For example, in that case, if you turn up late, I will be losing production. So you're aware of that at that time. So it's a very, very important point, both of those issues. The rising naturally is not really a big issue because you can see that that is a direct result of a breach contract, and that's damages. But once you get into this next second limb, which is to do with remoteness, how remote from the breach is the damages. And then the third part of damages is the duty to mitigate loss. So, and again, it's an old case, 1919, but these cases come up all the time, all the way through. And in this case, it was found that if you're already suffering a loss because of some issue, or so for example, take the mill. Let's say the mill was losing money as a result of the loss of production because the crankshaft was not fixed. But they knew they could buy a crankshaft for £500 rather than just continually losing loss day after day after day. They would have a duty to try to mitigate their loss by doing something about it. So therefore, that often again comes up with our type of work that people say, yes, okay, even if we're liable for it, you haven't shown that you've mitigated your delay. And therefore that almost puts a long stop on the amount that you can recover. So the first thing when you're looking for a common law damages claim is you're going to have to show there's a breach of a contract term. But obviously, even before you say there's a breach of contract term, you've got to find this contract term that you say is breached. So people sometimes say, oh, there's been a breach of contract. But if eventually you go to court or something of that nature, people will say, which term of the contract is it that's breached? Once you know which term it is, then you can show how was that term breached under the contract, and then you can start showing what the consequences of this breach are in terms of damages, in terms of either direct damages or consequential damages as a result from that. But also you have to show that you actually suffered a loss. So it can't be a theoretical loss, it's got to be an actual loss that you suffered. So again, there's an absolute multitude of cases that deal with the issue of how you calculate damages, but generally speaking it has to be based on the actual loss that you've incurred through the process. And the other big factor with any of these common law damage claims, or any claim in many ways, is the two main issues of burden of proof and standard of proof. So under this contract, under this common law damages, we have burden of proof and standard of proof. Now, the classic saying for the burden of proof is he who asserts must prove. So if you're putting forward this is your case, you've got to prove it. It's not for the other side to disprove it. You've got to actually prove your case. Now, that burden of proof can move over from one side to the other. So, for example, in our type of work, you would get a claim put forward by somebody on some sort of basis, on some sort of evidence, but it's up to them to prove their case. The other side might come back with a counterclaim. Now, when the counterclaim comes back, they've got the burden of proof to prove their case. So it can swap over from one side to the other in terms of burden of proof. So that's one really big thing. And we often see when we're acting as adjudicators that people don't actually prove their case. What they do is rely on the fact that the other party can't disprove their case. And we say, but you've got to prove your case. And then the other aspect is, which is very key again for the, particularly for civil litigation that we are involved with all the time, is the standard of proof. So the standard of proof is, under criminal cases, it's beyond reasonable doubt, whereas under civil cases, civil actions, it's on the balance of probabilities. So what that means is, if you've got a pair of scales, for example, and you've got to put enough in one side of the scale to prove your case in civil litigation, then all you've got to do is move that scale down slightly, 51%, 49%, you've proven your case on the balance of probabilities. If it's a criminal case, you've got to show it on beyond reasonable doubt. So you've near enough got to put that scale on the floor compared to this scale. So there's no comparison between the two. And there's been many cases over the years. I always refer back to the O.J. Simpson case back in 1995, where he and it came up again recently. I think there was didn't they find a knife or something in his garden or something? Anyway, he came up again recently. What happened was, most people might have heard the case, but he was accused of murdering his wife and with the wife's friend. It went to court, and under the criminal action, it was found he wasn't guilty of murdering his wife and the friend. But later on, there was a civil action taken against him on the basis that he did murder his wife and his friend, and he was found guilty under the civil action. And people think, well, how on earth can that be, that on one action he was found not guilty and the other action he was found guilty? And the reason is simply this issue of one was decided on the balance of probabilities. So on balance of probabilities, it's more likely than not that he actually murdered his wife, but on the criminal one, but you haven't proven beyond reasonable doubt that he murdered his wife. And so there's quite a few of these type of cases that are interesting to look at, to see that you think, is that a miscarriage of justice almost? Is there something wrong there? Because on one level, he's found guilty, on another level, he's found not guilty. But this is how the law works. On civil litigation, it's beyond reasonable doubt. And on criminal, it's beyond reasonable doubt. And on civil litigation, it's on the balance of probabilities. So again, if you transfer that to construction law cases, whenever you're presenting a case, defending a case, what you're trying to prove is on the balance of probabilities this happened. If we act as adjudicator or arbitrator, we decide it on the balance of probabilities. We don't need to be proven to us 100%. We need to be proven, in theory, 51%. But obviously you're a little bit flexible with the 51. That's a bit too close perhaps, but somewhere above 50% to be on the balance of probabilities. Now, obviously, you have this sort of conflict, if you like, between claims under common law damages and claims under contract. Because what happens in construction contracts is that people put in there provisions for recovering loss and expense, extensions of time for particular types of breaches that might occur under the contract. So these are almost like contractual breaches, if you like. They're things that people are saying, look, these are the sort of things that will come up during the course of this work. When these sort of things do come up during the course of this work, this is what will happen under the contract. So, for example, we'll come on a few examples later on, but let's say for loss and expense, you're delayed on the job for some reason. The contract then says you're entitled for these particular circumstances to get an extension of time, and you're entitled to get loss and expense. And as long as you follow the right procedure under the contract, you will get it. Now, that is all very well and good because that's the contractual provision. But does that mean that now you've got no right to common law damages? Have your common law damages been written away through the fact you've now got a contract provision? And sometimes it does and sometimes it doesn't. So if you look at the construction industry in the UK, for example, which is obviously what we do work abroad in the Middle East on FIDIC and that type of thing, but generally if you're working in the UK, there's only really two main contracts in use. One is the JCT form of contract and the other is the NEC form of contract. There are others, but when you look at the percentage of construction operations, probably still, even now, 85% of all construction work in the UK is carried out under the JCT form of contract, and the NEC somewhere between 5 and 10%. So, but the NEC is on some really significant jobs, so it's quite high profile and it's gaining ground, but they're the two main contracts. And they deal with this issue of what happens if you have a conflict between the common law damages and the contract provisions totally differently. So under the JCT form of contract, it says quite clearly that, well, I say quite clearly, nothing in contracts is ever written quite clearly, but it's fairly clear that if you don't comply effectively with the provisions in the contract, then you've still got the right to refer it to common law damages. So what you'll often get is the people to say you didn't put the right notice in at the right time, or it's condition precedent for some notice about delay or about loss and expense or something like that. And as a result of that, they'll say, therefore you've lost your right entirely to recover any money because that was your right under the contract. Under the JCG form of contract, they say there's a clause which says your rights and common law rights are still preserved. So in other words, even if you don't, as long as you claim it as damages and not as loss and expense, if you claim it as damages, then your common law rights are preserved, and you've got a safety net, effectively, to say, well, I missed the boat in terms of putting all the notices in, but I've now got it again because I've got common law damages. If you look at the NEC form of contract, which is growing ground, you don't get that right at all. So under the NEC form of contract, like that. Under the NEC form of contract, we obviously don't have that right because under the NEC form of contract it's excluded common law damages rights. So in that situation, it's a very restrictive contract. You have to give the notification within a set period of time, which is normally 8 weeks, which is a very, very tight period of time for giving a notification for extensions. Well, they call it compensation events under the NEC, but if we just consider it as being for extensions time or loss and expense or something of that nature, and if you don't give that notification in time, then you don't have the right to go to common law damages afterwards. So you can see it's very, very restrictive. Now, it's not really been tested that much in court, but we're pretty sure it would say that because the contract says quite clearly your only rights to recover under the NEC form of contract is through the compensation event procedure. So we think that would be how it would be decided. What we're going to move on to next is typical construction claims under the contract rather than under common law damages. Obviously, common law damages can be anything to do with the breach, etc. But under the contract, the things that we see coming up all the time are extensions time, linked in with that liquidate damages, and linked in with that as well, the extension time is loss and expense. So these are the three big headings that you see all the time for claims that are coming through. And the one that's always of interest is extensions time, because partially it's of interest because every single case is different, and secondly, frequently the court cases change the position from where you think it was established. So over the last few years, it's been established that Scottish law and English law is totally different about the way extensions time are dealt with, for example, whereas prior to that they were more in line and there was an overlap, but we now seem to have diverged completely in that respect. I'll come on to that in a second. But the reason why the right to an extension time under the contract exists at all is linked in with what the two issues are: prevention principle and time at large. So the prevention principle effectively is that if an employer prevents a contractor from completing the work on time, then that's an act of prevention, which is effectively making it impossible for the contractor to complete on time. Now, if there is such an act, say for example it could be instructions to come through to carry out the work, the instructions come through late. As a result of the instructions coming through late, it means that the contractor can't finish on time or some activity can't start. I'm making it simple because obviously there's a lot of delay analysis, but if we just think of the principle, information comes through late, that affects the program, that affects the completion date, therefore the contractor would be entitled to an extension time normally. Apart from if there's no provision under the contract that allows for that particular extension time to be made. So If there is no provision under the contract which allows that provision to be made, then time would become at large. It means that you can't set an end date. And we do see it quite often, even though people think it wouldn't happen. But take, for example, under the JST formal contract, you have relevant events which deal with extensions time. So what you need to do is find a particular relevant event in the contract which says if this particular event occurs, that gives, and if you show it delayed the completion date, then that gives you the right to an extension time. But say, for example, somebody went through the standard form contract, thought, one of the relevant events is that we give late information. If we give late information, that gives you the right to an extension time. But because we always give late information, what we'll do is we'll strike that clause out. So when eventually we do give late information, the contract will say, I want an extension time, and we'll say, oh, sorry, because we struck that clause out of the contract, you haven't got the right to an extension time. Then we will be in the situation of time at large, because obviously you've got an act of prevention by the employer, which you've demonstrated will affect the completion date, will prevent the completion date on time, but the contractor can't get an extension time because there's no relevant event in the contract that allows for it, and therefore time will become at large. And then we say, well, what does time at large mean? And this is another interesting area, isn't it? Because what time at large effectively means is you've got to finish within a reasonable time. And then obviously you've got to define what is a reasonable time for completing the works. And then we go into, well, what do the courts say about it? So I always quote the Shorten engineering case for this, which always makes me smile, but I don't have to make everyone else smile, but is what is a reasonable time has to be judged as at the time when this question arises in light of all the relevant circumstances. So what effectively it's saying is whatever it might be at that particular time will be a reasonable time. And most people, I think, look at it the other way around and say, well, what's an unreasonable time rather than what's a reasonable time? Because if it's unreasonable, it can't be reasonable. But there's no real great definition. And I think most people from our experience give up at that point and think, look, if we're in a time at large situation, you're never going to be able to prove it was reasonable or unreasonable. They just accept the fait accompli is that now time is at large, and therefore you can't set an end date. And that's certainly from our experience of dealing with these cases over the years. Not that time at large comes up regular, but it does come up from time to time, and particularly if any people here eventually get involved with drafting contracts or things of that nature. It's the sort of thing you could do quite easily where you think, oh, I'll be very clever and I'll take out one of these relevant events, not realising that actually it's going to backfire on you later on because you're taking out the very relevant event, which is going to cause the problem later on. So under contract, under either JST or NEC or any of the forms of contract, then before you even start asking for an extension time, you need to look into the contract to see have you got the right for an extension time under that particular provision. So let's say, for example, late information, is there a relevant event or is there a compensation event in the contract which gives you the right to do it? Because if it isn't, there is no point asking for an extension time for something that isn't in the contract. Now, when you start using the JST and the NEC regular, which eventually everyone here will start using, I should imagine, because like I say, it's still the most commonly used contract, JST and the NEC is gaining ground, you'll start to know these relevant events off the top of your head. You'll know all the events that can give you an extension time. You'll know all the relevant matters that can give you the right to loss and expense. Or you might not know them word for word, but you'll know the types of categories. So the first thing you will do is look in the contract to see if they've been amended. Is there any amendment to the contract which takes out any of these relevant events or any relevant matters? If not, then you're pretty sure that you can actually go for an extension time on the basis of a term of the contract. And so if it's not in the contract, you can't go for it. That's the first point. The second part, if there's a deletion, going back to this idea of deleting relevant events, if there's a deletion of something that's under the control of the employer, it causes a problem to the employer because the employer then could be in a situation where he can't give an extension time for something that he's liable for, and therefore time becomes at large, and we'll see in a moment what the consequence time at large is in respect to liquidated damages. So you can see that. But if it's something that the employer has no control over, and it's purely, for example, one of the common ones is exceptionally adverse weather conditions. So under the contract, under a JST contract, under the NEC contract, similar type thing. If there's exceptionally adverse weather conditions, then, and it causes a delay to the completion date, etc., we'll come on to that in a moment, then the contractor is entitled to an extension time. But for example, the employer could take those clauses out, and that wouldn't cause a particular problem. The only problem it causes the contractor, because the contractor now has the risk of including in his price, his time, his program for this risk that he thought was going to be normally shared or taken on board by the employer. So you can see there's quite a big difference between a relevant event that's down to the employer and a relevant event that's just neutral or down to nobody, it's just in the contract. So if that second category, i.e. exceptionally adverse weather conditions, wasn't in the contract, but it does cause you a delay, it doesn't make time at large because it's not a act of prevention by the employer. Now, under both the JST and the NEC form of contract, you're normally only entitled to an extension of time if you follow the provisions of the contract. So if you don't give the right notices, you're not entitled to an extension of time. So again, these are the mistakes that people make all the time, that they don't actually follow the contract in terms of provisions. They don't actually say what the relevant event is, they don't give the notice at the right time, and they don't show what the effect of this delay is. And over the years, the courts have applied these cases very rigidly. But again, if you get involved with looking at the court cases, and you can see that in the back of your folder, through, I've written now several books, but take for example, delay and disruption claims in construction, which is coming out as a third edition soon. BIM, that's not so relevant, JST, that type of thing. But when you do this research into these particular books, you look into these court cases and you realise that most of the time the courts are looking at the facts rather than some overriding principle. There are overriding principles, but the facts are more important in many ways to the court than the overriding principle. But one principle would be, for example, have you followed the provisions in the contract? If you haven't followed the provisions in the contract, then you almost certainly won't be able to get an extension time or loss and expense or whatever it might be. And the courts do follow this condition. If the condition precedent is clear that you have to put the notice in, they will follow it very rigidly. But if it's under a JST form of contract, for example, it doesn't really have so much impact because your common law rights to damages effectively override the contract provisions. Under the NEC form contract, it doesn't. So you can see there again, you've got to be very careful that you follow the provisions. So if you look at a JST form of contract, you put the notice in for a delay up to practical completion, and if you show that you've given the cause, the event, the relevant event, how it's affected the completion date, how it's affected the progress of the works on site, then in theory you'll get an extension time. But if you don't do that at all, eventually when you come to practical completion of the works, the CA or the contract administrator has to do that exercise anyway, irrespective of any notice you put in. So I always consider that to be a contractor's safety net, effectively, to say, well, okay, you weren't very efficient in putting all your notices in up to practical completion, but once you reach practical completion, then it's almost like a catch-up by the CA to say, I'm now going to review everything that was given to me in terms of notices, etc., and over and above that, I'm going to look at anything else that should have been given to me as notices but wasn't, and I'm taking all of that into account. And this is always a safety net under the JST form of contract. But the NEC form of contract is totally different. There you have 8 weeks and it could be amended. Bear in mind, Matthew's dealing with a case at the moment on a NEC form of contract where, and I've dealt with it in the past, where the Z clauses on the NEC form contract are a lever arch file thick. So you might think you know the NEC form contract, but the NEC operates on what they call Z clauses, which amend all of these clauses. So under the normal NEC form contract, you have an 8-week period to put the notification in, but there's no reason why under the Z clause it couldn't be reduced down to 4 weeks or 6 weeks or whatever period is agreed between the parties. Now, if you miss that 8 weeks or whatever the period might be, you've got no right after that to recover anything through common law damages, because your only way of recovering under the NEC form contract is through the compensation event procedure. So again, you can see, when the NEC first came out, I think many people called it sort of like the friendly partnering contract, but I think when you get more involved with it, you realise there's quite onerous conditions under this NEC contract that's fair, probably, because both parties understand it before they go into it, but you've got to really be on the ball in terms of operating the NEC form of contract. And then when you're looking at it from our perspective, either as advocates for the parties or defending a claim, or acting as we do as adjudicators, for example, then you have to think, well, this delay, what is the delay we're looking at? And there's two, again, distinct approaches for this under the JCT contract and the NEC form contract. So under the JCT form contract, what we're looking at is delayed, it's got to be delayed to the progress of works as a rider, let's say, but a delay to the completion date. So you've got to show that this particular event has not only caused a delay to the progress of works, but also will cause a delay to the completion date. Now, the reason I always put in the bit about a delay to the progress of works is because often you'll see a situation where somebody will say, I need a colour schedule for the paint on a certain date. I got it 6 months late, therefore the job obviously will finish 6 months late, because it's obvious, isn't it? If you get the colour schedule 6 months late, the job will finish 6 months late. Apart from the fact that when you're at that point, when you get the colour schedule, the brick walls haven't even been built yet by the contractor because he had no men on site. So therefore it wouldn't be the cause of delay. So it's got to be something that's affecting the progress of works on the site and will affect the completion date. Whereas under the NEC form of contract, you've got to show it affects the planned completion on the accepted programme. So this is a totally different concept. Under the NEC form of contract, you have a programme that's produced that becomes the accepted programme and becomes a contract document. Whereas under the JCT contract, a programme doesn't, rarely does it become a contract document. It's often listed in there, but the programme under the JCT form of contract is purely saying this is how I intend to achieve the completion date. Whereas under the NEC form of contract, the accepted programme is a contract document. And therefore, under the NEC form of contract, the delay is to planned completion. Now, planned completion might be earlier than contract completion, which is quite an interesting point, because often if ever you get deeper into this subject, you'll realise there's things called floats on programmes, and the period between the planned completion and the contract completion is effectively a terminal float. It means there's a period of time when you're saying as a contractor, I'll finish earlier, my planned completion is earlier than the contract completion. Well, because you're looking at delays against planned completion rather than contract completion, obviously that float the terminal float belongs to the contractor, and therefore that float effectively gets pushed in along. If you have float inside the programme, then that's owned by the contract effectively, whoever used the float first. It's a very important point. You might not think it's important now, but I can assure you when you get into these claims in more detail, you'll realise these sort of things are the things that people are looking at all the time. And what's quite a useful document is the SCL, Society of Construction Law Delay and Disruption Protocol, which is about on the point of being issued as a second edition. First edition was issued 10 years ago. You can still download it now, the first edition. It still sort of operates effectively. The second edition is out for consultation It doesn't really change the first edition drastically. It changes the emphasis in some areas. But if you downloaded the first edition, which I recommend you do, and you can actually even download the consultation document for the second edition anyway. So, you know, if you want to download both of them, do that. They're about 50 or 60 pages long. So it's not a massive document, but it's very good because it gives you a very good background for delay analysis techniques. It gives you a very good background for loss and expense recovery and things of that nature. And it's a very easy read. Now the point with it though is neither the protocol, either the first edition or second edition when it comes out, will not be, is not relevant to the JCT formal contract or the NEC formal contract. And the reason I say it's not relevant is because it's hardly ever, we've never ever seen it, and we've dealt with hundreds of different cases, never is it written in as a contract document. It's often referred to when you get into a claim situation or a dispute situation. People say, oh, the protocol says this or the protocol says that. But when you go back to it, it's not in the contract and therefore it's not relevant to the particular contract. It may be relevant to good practice and things of that nature. But what's good about it anyway is that it does set out delay analysis techniques. And if you're trying to think the best way to present a claim and you want some authority, let's say, at least you can say, well, this document, which is sort of recognised as authority, I think people use it all over the world actually, but certainly in the UK people are often referring to it, even though, like I say, it's been undermined a bit, only because the second edition slightly undermines the first edition, but put that to one side, it's a very useful document. And if you download it, you'll see that there's quite a few aspects in that document. But if you look at the 4 main delay analysis techniques are listed there, which are used all of the time. And some of them are pretty easy to understand, and the failings with them are pretty easy to understand as well. So the first one, for example, is an impacted as planned analysis. And what this is that you've got a program that's produced at the beginning of the job, a construction, either a tender program, contract program, whatever you want to call it, doesn't matter. This is the program, how you anticipate carrying out the work. A delay event comes up at some point or other towards the beginning of the job. You impact that delay event on the program, and all you do is then basically shunt the rest of the program on by the effect of that delay event. Then you find another delay event comes up, you shunt the program on, find another delay event, shunt the program on. The downside with it is it's very theoretical, because all you're doing is saying, in theory, this event had this impact on this program, and often we find that the actual job overrun by 3 months, but through this analysis, it actually overruns it by 6 months. So actually this impact is kind of pushed on by 6 months, but the actual job only overrun by 3 months. And then contractors obviously say, well, the reason for that is because we use such extraordinary measures to bring the program back, which is a bit tongue-in-cheek, but even still, you can see that's one approach. People don't really like it much because it's too theoretical in that way. You got the time slice analysis method, which is probably the most preferred, I'd say, because it's more analytical. But in reality, it's quite similar to the impact as planned analysis. The only difference is that you're now breaking it down into normally monthly periods, and you say, in this month, what caused the delay in this month? You're then projecting it through, but you're also saying, how can I reprogram the program so that I mitigate, going back to our issue about mitigation earlier, how I mitigate that delay. So you're now doing it on month by month or period by period, whatever it might be, all the way through. And this is much more realistic because obviously you're now taking on board every month the actual progress on site, and you're saying, well, this is what actually caused the delay. So I think that's the preferred method for most people. I'll come on to the downside of that in a moment. You got another option is just purely to overlay the original plan program with the as-built program and say, well, look, that bar should have finished then. It finished then. What caused that delay? So you can see again, it's very simplistic, but also very effective in some ways. So that's another option. And the other one is the collapsed as-built program. Now, this program is where you get a program that shows how the job was actually built with as-built data from the site records, and then you work backwards from the end and you say, if it hadn't have been for this event, the last event that caused us delay, we would have finished earlier. And often people call it the but-for program. So therefore, if we hadn't have had this delay event right near the end, we would have finished, but for that, 1 month earlier or 1 week earlier or something. And you work backwards and backwards and backwards till eventually you come back, oh, that would have been the original contract completion date. So the point with all these is that none of these are listed in the JST contract, none are listed in the NEC formal contract. Some of them, the time slice analysis, for example, could cost a lot of money to produce, and you've got to have very good records, and you've got to weigh up and think, well, how much is this dispute actually worth? Is it worth us spending £50,000 to produce some beautiful claim when the claim itself is only worth 25,000? Well, probably the answer to that is no. You know, so there's lots of other factors you have to take into account before you decide on the approach. But I'd certainly recommend you look at that if you look at the protocol, because it is a very, very good document. Now, liquidated damages is a commonplace feature in all most construction contracts, and liquidated damages is a figure that's put in to say that if you overrun on this particular job by a tool, then there'll be a liquidated damages charge per week for every week you overrun. Normally it's on a week by week basis. And a figure is put in the contract to say this is how much will be the charge per week, and it's agreed by the parties, or agreed by the parties, put in the contract, and therefore both parties sign it, therefore they've agreed to the contract, and they know that the liquidated damage will be £5,000 a week, £50,000 a week, £20,000 a week, whatever it might be, is in the contract. And it's normally stated literally on the basis, most of the ones we see is purely so much per week or part thereof. So it's fairly easy to understand. But as we touched on before, if time is a large, then you can't set an end date. And if you can't set an end date, then you can't apply liquidated damages. Because how can you set liquidated damages, say you should have finished on that particular date, you didn't finish on that date, therefore liquidated damages apply. And that is one of the main reasons why we have this issue of extension of time provisions in the contract to allow the completion date to be extended, because if you can't allow the completion date to be extended, liquidated damages can't be applied. And we'll always go back to the old 1970 case, Peak of McKinney versus McKinney, which set that principle of you can't apply liquidated damages unless you set a completion date, and if time is at large, you can't set a completion date. Now, the rule which still applies, even though there's a Supreme Court case which changed an emphasis a bit, which I'll come on to in a moment. But the general rule is liquidated damages under English law can't be a penalty, so it can't be penal in nature. You think, well, surely it's penalty, because if I overrun on the site, I'm going to be charged £10,000 a week. That sounds like a penalty to me. But what it means is it can't be penal in nature. It can be an agreed figure, because both parties have agreed this figure. Bearing in mind, if you didn't have liquidated damages, you would have unliquidated damages, and the unliquidated damages could well reflect the figure of the liquidated damages anyway. So as a contractor, you're not any worse off by having liquidated damages. You're probably better off in some ways, because you know the extent of the damages you will incur if the contract overruns. But it can't be penal in nature, and until very recently, we always used to use the phrase, it has to be a genuine pre-estimate of the damages, and that was quite a good defence. You'd say, well, can you show us how you built up your damages before the contract was formed to show there was a genuine pre-estimate of damages? But the Supreme Court then had a hand in that, and there's two cases back in 2015, and they said, well, actually, this issue about it being a genuine pre-estimate of damages doesn't apply anymore, or isn't the main criteria, and doesn't really apply at all. And what they're saying is, there's two cases, Cavendish Square Holdings and Parking Eye Limited. They were both decided at exactly the same time. It was done at a joint session in the Supreme Court. Again, it's worth reading those cases because they're very interesting cases. And what that is, consequence of that really was that the test for a penalty now relates to whether the impugned provision is a secondary obligation which imposes a detriment on the contract breaker out of all proportion to any legitimate interest of the innocent party in enforcing the primary obligation. That sounds very complicated. But what it's really saying is the amount of damages totally disproportionate to what it should be in respect of what the parties have agreed. Now, you might think, well, if the parties have agreed it, they're free to contract on what they like, and they've already agreed this figure. And basically, the Supreme Court was saying that, effectively, it'd only be in an extreme case, a very extreme case, you'd be able to overturn it on a penal nature on the basis that you'd show it was totally disproportionate to the interest of the party if you applied this particular rate. Now, but that's been pretty much the same before. Even before, when it was a genuine pre-estimate, it was pretty much the same. That sometimes we would have clients come to us and say, oh, you know, liquidated damages are £20,000 a week. It sounds a hell of a lot of money to us. Can we go to court and say it's a penalty? Even before the Supreme Court case, and we would say, your chances are pretty remote. In fact, very, very remote. It's hardly worth it because they're going to be able to prove that they did a genuine pre-estimate. And once they prove they did a genuine pre-estimate prior to the Supreme Court cases, then you're near enough blown out of the water. Now, you've got to show that it's something that's so far out of proportion. And again, the Supreme Court of making it fairly clear that the parties are free to agree pretty much what they want to agree. And the last section we're going to go on to is the typical heads of claim for loss and expense. Now, bear in mind, under the NEC form of contract, you don't actually have loss and expense. You have, under the NEC form of contract, compensation events, which really collect together extensions, time, and loss and expense, and the cost of the variation and everything into one big thing called a compensation event. Under the JST form contract, you have extensions, time, and loss and expense separately, and this really is more tuned towards JST form contract in terms of loss and expense. And the three main heads of claim that you always come up with are prolongation costs, head office overheads costs, and disruption. And within those, there's quite a few subheadings. Now, prolongation obviously means that if a contract was going to take 50 weeks and it actually takes 60 weeks, you've been on site for 10 weeks longer. As a result of that, being on site for 10 weeks longer, assuming you find the right clause in the contract, you give the right notice, you would then say, well, I've had my resources on site, my site staff, my huts, my everything else on site for a 10-week period longer, and all the other things that go with it, electricity, water, plant, etc., has been on site for that longer period. And therefore, I want to be paid my extra cost per week for the prolongation. And that is probably the easiest part of the claim, assuming A, that you can show that you incurred the cost, B, that you can show that the delay event or the relevant matter in this particular case was the cause of you incurring loss and expense. So we've got this cause and effect scenario again under this form of contract. But that's fairly simple and everyone understands it. It gets complicated a bit because when contractors price for work, they tend to price very keenly for work, but when the actual overrun comes, they're looking to recover their actual cost. So people say, well, when you was running the job normally, you had £5,000 a week for your prelim costs. Now suddenly, when we're in delay, you got £15,000 a week for your prolongation costs. So why is there such a difference? And obviously, there's the argument about, is there sufficiency of tender in the first place? Was the tender set at the right level? And over and above that is the resources you got on site, the resources you need to have on site to carry out that particular work on site. So it's all to do with cause and effect, proving actual loss. But once you get over those hurdles, you're pretty much okay with prolongation costs. When you come to head office overheads, that's the same sort of principle in a way. What people are saying is, well, I've been on site for a longer period of time. My head office is still involved in the background looking after the site, so I want to recover my head office overheads relating to that site overrunning. Now, the problem with head office overheads is because if you're a big company, you've got 20 contracts running at any one time, the fact that one particular contract overruns for another 10 weeks, it's quite difficult to show that you actually incurred any extra head office overheads as a result of that one contract overrunning. And the only way you can really show it is if you can show, well, I would have put my resources onto another job, but I couldn't because they were tied up on that job. So one of the key things with head office overheads is to show that you've turned away other work. If you can show I turned away other work because all my resources were tied up on this job, then you've got a bit of a chance. And once you get a bit of a chance, you can start using a formula approach, Hudson's, Emden's, something of that nature. The courts do accept it, and going on from there, I think, particularly after the Water Lily case, two or 3 years ago now, and other cases around at that time, and even before that, people thought you had to be absolutely rigid about what you can recover. But the courts are a little bit flexible. They're saying effectively there might be some entitlement to this. If you improve it in more detail, you're going to get more. If you prove it in less detail, you're not going to get so much. So it's almost like the emphasis is back on the person who's trying to prove their case all the way through. So it's quite an important point to bear in mind that head office overheads we always think is a pretty weak argument because we know we're going to have difficulty getting it. But if you present it in the right way, if you show you've incurred the cost, if you show that you've turned away work, and if you can produce on some sort of formula basis that's acceptable to courts, then you've got a bit of a chance. And the other big element of claims is disruption. So in this particular case, you might have a case where you're carrying out the work on site, you're given lots of information, lots of instructions, coming late, etc. And as a result of that, you're saying my work on site was disrupted, I was delayed. You normally say I'm delayed and disrupted. But the disruption part is where you're not getting the production you thought you was going to get from your operatives as a result of being disturbed in your progress and disrupted in your progress by these particular events. And again, it's very difficult to prove disruption. So the classic way in the past has always been what they call the measured mile approach. So under the measured mile approach, what you show is, well, before this event happened, which caused me disruption, my production was such and such. So say, for example, bricklayers are doing 60 bricks an hour, which is pretty typical for a bricklayer, laying 60 bricks an hour all the way through. And suddenly this disruption event comes in and the bricklayer is now only doing 30 bricks an hour. And therefore, I've lost 30 bricks an hour production because of this disruption. Well, that sounds beautiful in a textbook, but to try to apply it in real life is pretty hard, because you never have a run of work long enough to actually show this is what I would have achieved, and this is what I did achieve, and this is what I actually achieved afterwards. But the principle is there, and people quite like that principle. But if not, then what the fallback is then is people say, well, across the board, I had a disruption factor of 5% or 10% or 20%, which is obviously nowhere near good enough, because you've got to prove your case again. So they're the main headings of loss and expense. And really, I think that's sort of the main issues I was going to cover. And the last slide says questions. So I'm more than happy for questions.
Thank you very much, Peter. About this last one, the disruption one, I had the experience inside once. We claimed disruption against the client, and he came with the team the next day to record each bricklayer who was working and for how long they were working. Everyone, the carpenters and etc. And at the end of the day, it was a counterclaim because we were actually unproductive and not as productive as we were thinking we were. Yeah. So it's tricky. Thank you very much, everyone. Thank you, Peter. Thanks, John, for coming. Does anyone have a question? Let's start with questions. We are recording.
Yeah, I'd like to ask you about prevention principle and concurrent delay issues.
Yeah.
Yes. Prevention principle is very important doctrine in common law, right?
Yeah.
So, but if in the case of concurrent delay, the contractor is not entitled to recover loss and expenses. The contractor is entitled to claim only extension of time to the completion, right? But I think there is a conflicting between prevention principle and the consequence of concurrent delay, because if there is significant delay in construction project, for example, 1 year, 2 years, so there is usually there is a limitation or a cap on liquidate damages. Usually, 10%, maximum is 15%.
Well, no, not usually. That isn't usual. It happens, but it's not usual.
But limitation is usual.
Or limitation on liquidate damages? No, it's not usual.
Not usual.
No. It happens, but it's not usual.
Okay, so if the contract say there is a limitation, for example, 10%. So, but if there is a significant delay on construction project, the contractor can hold the liquidate damages and some amount for concurrent delay. But I think no compensation is also additional liquidate damages for contract side. So yes, as I told you, if one construction project is delayed, for example, 1 year or 2 years, usually limitation of liquidate damages can reach the maximum only at 100 days, usually 3 months.
When you say you say usually, this isn't usual.
Yes, but if the construction project delayed over 1 year, the employer can hold payment beyond the limitation of liquidate damages, just for the reason for concurrent delay.
The normal situation is you have liquidate damages per week, and however many weeks that overruns, the liquidate damages apply. If it happened to be 3 years, it'll be 3 years worth of the liquidate damages. It's not common, certainly in my experience, and I've dealt with lots and lots of contracts, for it to be capped, particularly with the contractor and an employer. So, but the point you're making, I think, is the concurrency argument, which again, you have to remember is different in Scotland. So in Scotland and England are different. Scotland, you've got the City In case, which said that when you're talking about delay, and and loss and expense, we'll talk about delay first, you get a proportion of delay under the Scottish approach. Under the English approach, which is the Water Lily case, you effectively get all of the delay, but because the act of prevention comes into place, therefore you're entitled to the full period of delay as a contractor. But the Water Lily case says, doesn't quite say, but when you read between the lines, it says, but you don't get loss and expense. Whereas in the Scottish approach, you get proportional between time and money. So proportionate in Scotland. In England, it's all or nothing. Now, that's only if you've got concurrent delay. But how often do you have, well, A, what is concurrent delay? And B, how often do you have this thing called a concurrent delay? So we think a concurrent delay means 2 delay events happening around about the same time, one being down to the employer and one being down to the contractor. But there's other definitions which say, it's got to start on the same day and finish on the same day, and therefore it is concurrent. And there's others which say, actually, it's got to be of equal potency to be concurrent as well. So there's lots of other factors, and this is the point I was making, that when you go through the court cases, more often than not, the principle is there in the background, but it's actually decided on the facts. But I think your point is, if there was a cap on liquidated damages, it can't be fair, is what you're saying.
But according to the prevention principle, the default party cannot take any benefit from his default, right? That is the true meaning of prevention principle. But beyond the limitation of liquidated damages, no compensation can be additional LDs for contractors.
But bear in mind, this is what the parties have agreed. The parties have agreed. They knew this. They knew the chance might be the contract could overrun by 3 years, let's say. But they knew, with that knowledge, they've agreed a liquidated damage figure, and they've agreed a limitation. So somewhere along the line, the employer might afterwards think, I wish I'd never agreed that limitation figure, but he's agreed it, you know. So, but I understand with the point you're making.
Hi, yeah, just a quick one on NEC. Do you feel that the Z clause facility is a built-in fault and leads to overcomplication?
Well, if you read the NEC themselves, they say when you go into the NEC contract, the Z clause is one line in the contract, and it says Z clause, additional clauses of the contract. And the guidance notes points you very much away from having Z clauses, because the whole point of it is these various contracts, because you've got various different options under the NEC, have been put together so they're balanced and they represent both parties, not necessarily interests. Under JST, they both represent both parties' interests. So under the NEC, this is how it's structured. This is what it is. As soon as you put a Z clause in, that throws out that structure. And sometimes you don't realise the effect of that particular Z clause might have an impact on another clause further in the contract. So going back to your question, yes, I think it wasn't designed to be Z clauses apart from that one line which says Z clauses, additional contract clauses. But as soon as you start doing it, the NEC could become, and often does become, a totally different contract. It's not really the NEC anymore. It's just another ad hoc contract that's been used. The NEC has been used as a coat hanger, and on that coat hanger, people put all these clauses they like to put onto the coat hanger, really.
Yeah. Thanks.
Anyone? Question? Thank you.
Thank you. It was very interesting. Peter, you were talking about liquidated damages. I've just and also you mentioned about common law damages as well.
Yeah.
My understanding is that employer puts in liquidated damage fee to the contractor for any delays or anything else.
Yeah.
My question is, apart from the liquidated damages, is there any other way an employer can claim for common law damages as well? If there are any delays, if there are any breach of contract by the contractor?
Right. Normally you have a liquidated damages clause which knocks out unliquidated damages. If you don't have a liquidated damages clause, then common law damage, unliquidated damages would come into play. I think you could have, it's very difficult because people put in the contract sometimes liquidated damages nil, let's say. Well, if it's liquidated damages nil, I think it's accepted by everyone. There's no liquidated damages and no unliquidated damages. Sometimes people put in liquidated damages NA, not applicable. Therefore, liquidated damages aren't going to apply, but unliquidated damages would apply. But you do also get a case similar to this idea of a cap, but not quite a cap, where it says for the first 4 weeks, liquidated damage will be this. The next 4 weeks, liquidated damage will be that. Doesn't say any more apart from that. So the job overruns by 10 weeks. So it's past that 4 weeks and 4 weeks, you're into the next 2 weeks. And the question is, which is a pretty much unanswered question, unfortunately, is does at that point unliquidated damages come back into play, or have the parties effectively put a cap on the liquidated damages by saying, well, that's the extent of the liquidated damages and therefore no unliquidated damages come into play. So that's the sort of grey area, I'd say, in that particular case. But generally, you either have liquidated damages or you have unliquidated damages.
So does that actually mean that the common law damages does more favour the contractor rather than the employer? Or
No, no, not really, because not necessarily. Particularly in the old rule, under the old rules, you would have it had to be a genuine pre-estimate. Now that's gone by the board, but let's pretend for the moment it had to be a genuine pre-estimate. This genuine pre-estimate had to be what does the employer anticipate the damages will be if the contract overruns. So in theory, it would be no different if it was unliquidated to liquidated. Now it's slightly different because they don't say about the genuine pre-estimate anymore, but they say it has to be proportional. But let's pretend it was still genuine pre-estimate, and it's going to be about the same. The benefit to the contractor is he knows that is how much I will get stopped every week. And I mean, I've been in contracting years and years and years, and often a contractor would think, oh, it's £5,000 a week liquidated damages. I think I might overrun by 6 weeks, so I'll add on to my price £30,000 to compensate for the fact when I do overrun by 6 weeks, I can pay off the liquidated damages from, mind you, you've got to win the job, obviously, which is another factor, but put that out of it. Whereas unliquidated damages, they don't know. They don't know what it'll be. They haven't got a clue what it'll be. It'll be what it'll be at that particular time. So I think most contractors prefer to see a liquidated damages clause. They don't like to see the number always because it's a bit big, but it is to the benefit of the contractor to have a liquidated damages clause, generally.
Thank you. Thank you. That was very good. Very thorough answer. You were also talking about prelims.
Sorry,
you gave an example of prelims. Say
prelims, yeah.
During tender process, where sometimes contractors do tend to actually underbid. Yeah. And when they win the works, they then after, if there is any prolongation, of course, or something, they will then sort of like the rates that they'll be using that they use in the tender tends to differ from the others, from the variation or anything else they've actually claimed for. Yeah. How would you tackle that sort of situation if you consider, if just say for me being a commercial manager, how would I tackle, or is there any approach that I can go to the contractor to say, is there any other this and this is what, or is there a sequence or guidelines for me to go through?
No. But I think say for example, in the original tender, they allowed for one site agent, let's say, and then when the job's overrunning, they suddenly have 3 site agents. Then you'd say, well, what is the cause? It all relates to cause and effect. What is the cause of this delay or this disruption or whatever it might be that has had the effect of you having 2 extra people on site? Now, if they can't show that cause and effect, then they haven't satisfied, even going to our low level of reasonable balance of probabilities, they haven't shown it, have they? They haven't shown why is there. So often what you would normally do is you'd have a schedule showing all the resources that was allowed in the tender, another list next to that of what resources are actually shown now, and you'd ask the question, why have you got these extra resources on site? You've got to prove to me that either your tender was insufficient in the first place, if so, that's your problem, even though there are a lot of arguments against that. Or alternatively, you're using the job purely because you haven't got much work on, and you're putting all your labour and all your staff on there, expecting to recover it from me. Well, unless you can show through this cause and effect that actually what I've caused you a problem with is the result of that, is the cost, then I'm not paying it, But you've got to schedule it, otherwise you can't itemise it. That's the point.
I also do believe that although contractors actually, the main point of actually having a contract is not to construction, they tend to be more dispute most of the time. But as most adjudicators do actually say, there is actually best to actually avoid dispute, which you already said. In what way should I actually approach it rather than going to the contractor and say, I don't want to pay for it? Because in this economic situation that we're in at the moment with Brexit, most contractors can go, well, if you're not paying for it, I'll just walk out. So to an employer, or me working in favour of an employer, what approach should I take? Is it best for me to actually say, well, okay, I'll pay for it, you just go on and keep working finishing the work, or I just go on and actually try and find somebody else to actually do the works and finish the works?
Well, depends on a lot of factors, but the contractual situation is they've got a contract to do the work. They are entitled to be paid prolongation costs if they can show they're entitled to be paid it. They can be paid so much per week if they can prove it, etc. You pay them that in line with the terms of contract. If they say, well, if you don't pay me what I'm asking for, I'm walking off site, then normally under the contract you say, well, if you walk off site for that reason, then you would have repudiated the contract. I'll accept your repudiation. I'll have to get somebody else on board to finish the job off, and it's going to cost you a lot of money, and I'll take you to court to get the money back. That's the legal argument. The real world argument obviously might be totally different, because this particular subcontractor might have no money in the bank, and therefore what's the point of saying to him, it's going to cost me another £150,000 to get the job finished, knowing he's not going to be able to pay the £150,000 to you anyway. So this is the problem. In the real life, you have to weigh it up a lot.
But would that not cost the employer more money? Although they're probably taken to the court, doesn't necessarily mean that the next contractor who's going to come in is going to say, well, okay, I'm going to take on this risk based on the fact that maybe the other contractor, the previous contractor, might have done half of the work already.
Yeah.
And in that case, you have to go through a whole different procurement route rather than actually...
Yeah, and it could cost a lot more money. It could cost a lot more money. But if you knew that you could recover that extra overcost from the contractor at number one, then you think, well, okay, I'll recover it from number one. The chances are, you're not going to be able to recover it from contractor number one, because they might fold the company up. Anything could happen, couldn't they? Or they might dispute it. They might say, well, actually, it's not all down to us, etc. Come up with all sorts of arguments. And sometimes, not in the contract world, sometimes in the real world, it is worth negotiating with them and saying, look, I think you're totally wrong. I think it's totally wrong what you're doing, but we want you to get the job finished, and therefore we'll pay you an extra X £1,000 to get the job finished. But that's not a contractual argument. That's a commercial argument in that respect.
Thank you.
Well, thank you, everyone. I think we ran out of time to take a last question, unless it's really, really quick. But we have the opportunity of having, I don't know, snacks and very good wine provided by the University of Westminster. Thank you very much, Peter. Lovely.